describe the various rights of an arrested person under the Cr.P.C. Can a magistrate refuse the request of an arrested person for medical examination of his body? If so, under what circumstances? ANS. Chapter V of Code of Criminal Procedure contain provisions regarding arrest and rights of an arrested person. Section 49 of Code says that the person arrested shall not be subjected to more restraint than necessary to prevent his escape. Section 50 of Code further provides: 1. Every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offense for which he is arrested or other grounds for such arrest. 2. Where a police officer arrests without warrant any person, other than a person, accused of a non-bailable offense, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. Section 51 then provide when on personal search of an arrested person contain articles are seized, a receipt showing the seizure of such articles shall be given to that person. Section 53 of Code confers a right upon the investigating agency in respect of medical examination of arrested person for facilitating effective investigation. Then Section 54 of the Code provides: when a person who is arrested whether on a charge or otherwise alleges, at the time when he is produced before magistrate or at any time during the period of his detention in custody, that the examination of his body will afford evidence which will disprove the commission by any other person of any offense against his body, the magistrate shall, if requested by the arrested person so to do, direct the examination of the body of such person by a registered medical practitioner unless the magistrate considers that the request is made for the purpose of vexation or delay or for defeating the ends of justice. In Mukesh Kumar v. State, Delhi Administration, 1990 Criminal Law Journal, 1923, it was observed that in view of Section 54 Cr.P.C, whenever a person after being arrested is produced before magistrate and alleges at any time during the period of his detention that examination of his body will afford evidence which will disprove his commission of offense, the magistrate shall direct him to be examined by medical practitioner unless magistrate considers the request as vexatious. Even in cases where accused does not make any prayer, it is the duty of the court where such an accused is produced, particularly when he is unassisted by a lawyer, to inform him of his right to be medically examined. Then Section 56 of Code provides, a police officer making an arrest without warrant shall without unnecessary delay and subject to provisions of Code as to bail, take, or send the person arrested before magistrate having jurisdiction in the case or before the officer in charge of police station. Section 57 also provides that no police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable, and such period shall not, in the absence of a special order of a magistrate under Section 167, exceed 24 hours exclusive of the time necessary for journey from the place of arrest to the magistrate's court. In Joginder Kumar v. State of UP, Air 1994 SC 1349, it was observed, no arrest can be made because it is lawful for the police officer to do so. The existence of the power to arrest is one thing. The justification for the exercise of it is quite another. The police officer must be able to justify the arrest apart from his power to do so. Arrest and detention in police lockup of a person can cause incalculable harm to the reputation and self-esteem of a person. A person is not liable to arrest merely on the suspicion of complicity in an offense. There must be some reasonable justification in the opinion of the officer effecting the arrest that such arrest is necessary and justified. Except in heinous offenses, an arrest must be avoided if a police officer issues notice to person to attend the station house and not to leave station without permission would do. Then, there is the right to have someone informed. That right of the arrested person, upon request, to have someone informed and to consult privately with a lawyer was recognized by Section 56(1) of the Police and Criminal Evidence Act, 1984 in England. These rights are inherent in Articles 21 and 22(1) of the Constitution and require to be recognized and scrupulously protected. For effective enforcement of these fundamental rights, the Supreme Court issued the following requirements. 1. An arrested person being held in custody is entitled, if he so requests, to have one friend, relative or other person who is known to him or likely to take an interest in his welfare told as far as is practicable that he has been arrested and where is being detained. 1. The police officer shall inform the arrested person when he is brought to the police station of this right. 3. An entry shall be required to be made in the diary as to who was informed of the arrest. These protections from power must be held to flow from Articles 21 and 22(1), and enforced strictly. It shall be the duty of the magistrate, before whom the arrested person is produced, to satisfy himself that these requirements have been complied with.